on the record on our civil protection order calendar. We have a couple matters on this afternoon. The first matter that we are going to address is a telephone status conference. This is a matter of Clarence Moriwaki versus Richard Rynearson, 12-17. We're trying to get the parties on the line. There was an issue with the attorney not being...
The attorney's on the line right now, and Mr. Moriwaki.
Okay, and so are they on right now?
Yes, and
Okay. All right, this is cause number 12-17, and this is the matter of Mr. Moriwaki versus Mr. Rynearson. I understand I have the petitioner and the respondent's attorney on the line. Can you hear me, Mr. Moriwaki?
Yeah, I'm here.
All right, and Mr. Savani?
Yes.
All right, and so my clerk tried to get your client on the line and was unable to get through to him.
Okay, let me see if I can call him on another line of mine, and I can put him on speakerphone so he can then hear us.
Okay, why don't you go ahead and try that for the moment, and we'll see if that works.
Okay, just one moment, please. Because we tried calling and we weren't able to get it to work. So I'm going to put them speakerphone, then I'm going to put my phone on speakerphone so you can listen. Okay? It's covered. So, here, I'm going to put you on speakerphone now. Just a second. Yeah? Okay. Okay, I'm going to put myself on speakerphone now. Just a second, please.
Okay.
Is everybody still there? Yeah.
All right, so can you, Mr. Rynearson's now on the call?
Hopefully. Can you hear the court? Yes. Okay. You can hear now.
All right. Okay, so again, this is cause number 12-17, and we are here for a status hearing. The reason that the court set the status hearing was because the respondent had originally requested a continuance to investigate the possibility of whether or not criminal charges were going to be filed stemming from some of the conduct involved in this case. Mr. Savani, have you been able to gather any additional information related to that?
Basically, yes and no. I reached out to the prosecutor again about a week and a half ago asking as to the status of the case, and he informed me that a decision has not been made, but that he would contact me as soon as a decision has been made as a matter of professional courtesy. Since that time, the prosecutor has not contacted me, so as a result of a lack of communication from them, I can only assume that a decision has not been made charge-wise. Additionally, I have not seen any indication of any charges online, so I'm only left to believe that a charging decision has not been made,
Okay.
and whether it be to charge or to decline, as to the lack of communication from the prosecutor.
All right, and is the prosecutor aware of the fact that there's pending civil litigation and that it's...
Yes. When I first reached out to him about a month ago, I made him aware of this pending case. That was before we initially appeared in person, Your Honor. And at that time, he thought a decision was being made quickly, but the lack of response has indicated apparently a decision has not been made quickly. We're just kind of left here waiting to see what they have to say, but unfortunately I don't really have any more information as to a timeline from the prosecutor other than any day now.
Okay. And so what is your position regarding going forward with this matter and setting
I think both myself and my client agree we would like to have one last stay for maybe about 4 weeks, and if a case, if we don't get a decision from the prosecutor at that point, then I think we probably will be proceeding shortly thereafter. But I think one more status conference meeting would be appropriate.
All right, and Mr. Moriwaki, response?
Yeah, plenty. Could I ask the counsel, if I just heard him correctly, he said he only contacted him a month ago prior to our court proceeding? Is that correct?
Well, that was the first time I contacted him, seeing if there was going to be an answer, and at that time he hadn't even looked at the file at that time. Then I contacted him again about a week and a half ago, and he said no decision had been made.
Okay. Yeah, I misunderstood your previous statements. You didn't say it a week and a half ago.
Well, it's always challenging on these telephone conference calls to hear thoroughly. All right, so Mr. Moriwaki, he's asking for another status hearing 1 month from now to revisit the issue due to the fact that there may be criminal charges pending. And so do you have a position?
Yeah, I totally oppose it as my previous position. Again, this is a civil situation. I'm simply asking for a protection order, hopefully permanent. This is just to stop the cyberstalking, which the court has given me that temporary order. There's not, other than, I don't know what the criminal proceeding has to do with it, whether that goes on or not. The case is closed. The Bainbridge Island Police Department has already submitted their statements, 2 of them, to the prosecutor. As counsel knows, that was 2 months ago or more. So, again, this is sort of like saying the judicial system can't walk and chew gum at the same time. They're 2 totally different situations. I'm just asking for permanent protection from the end of the cyberstalking and all the other harassment. I want a buffer zone and such, and the prosecutor could decide tomorrow, he could decide in 6 months. That's really irrelevant to the protection order. He's been in violation of the cyberstalking statute, as you have determined with the award of the temporary protection order, and so there's really nothing new that could be done from a criminal proceeding. The criminal proceeding would just be the adjudication of the prosecutor saying you have violated the law, you've made a determination, that that's happened because of the evidence I presented just on its face that he did violate the cyberstalking statute. So I'm just asking for my personal protection, and I don't see why the stay in another state is necessary. And then I'll further add that this is just continuing more. It's not just the Harrison issue, but I'm having to live this every time I have to come to one of these meetings. I just need closure on this. It's really frustrating. It's dominating all my life, a lot of my time. It's stressing me out. And that anxiety just has to come to an end, and it would be the relief of having the permanent order, and I could be done with it.
All right. I understand your position. I think the issue here is that he has a Fifth Amendment right to remain silent about any potential criminal allegations against him, if those are going to be going forward, and whether to know whether or not those are going to be going forward, whether in order to determine whether or not his client should provide statements about this incident or not. And so the court often runs into this situation where we have a parallel matters going on, a civil matter where you're seeking to get a civil order against somebody, but then they are potentially facing criminal sanctions out of the same exact conduct, and feel concerned about responding to it under oath in a court where things are being recorded and whether or not that should be done. So the court understands the position of the petitioner. However, I feel that I can't force the respondent to go forward at this point without further information. I am going to grant the request for the continuance to June 20th at 1 p.m. This is going to be, again, a status conference. I think the position is reasonable, is if there's no criminal charges filed by that time, then the the respondent would be in a position of being willing to go forward at that time, and that's what the court would be inclined to do. And then if there is criminal charges filed by that time, then there will be more information for the court about going forward. The concerns about that the petitioner have are mitigated by the fact that I'm continuing the temporary order in all of its terms through the next court hearing, so that will remain, and in all of the terms that were previously listed. So we, let's see. I'm taking a look at the temporary order. Just a moment, I need to get to the right place. All right, so the temporary order that is continued is the one that was issued on 4/24/2017. The terms of the order are not to have any contact with the respondent may not have any contact with the petitioner, may not keep him under surveillance, is excluded from his residence or workplace and any public events where the petitioner is present. He must stay away from his 300 feet away from his residence, workplace, any public events where he may be present, and he is to remove public web pages, Facebook page with the petitioner's name. And he is to surrender weapons, which he has already done. Now, I know there was a motion that was submitted by the petitioner, one to clarify the foot amount, which the court denied based on the fact that would impede his ability to reside in his home and ingress and egresses to his home. And then the other one was submitted basically requesting that any mention of Mr. Moriwaki's name be removed from his Facebook page. And I can understand the desire on the fact of the petitioner of wanting to have his name removed. However, I don't think that was exactly the court's intention. At the time, there was a Facebook page named Not Clarence Moriwaki, and there was a bunch of information that was posted on there that the court granted the temporary order based on and that was more harassing in nature. And the information that was submitted by the petitioner was sort of old posts that were did not appear to be harassing in any way. We just referenced Mr. Moriwaki's name, and I don't think that was what the court's intent was to that the respondent had to sanitize any listed name of Mr. Moriwaki. Does that make sense, Mr. Moriwaki?
Yeah, yes, I would strongly disagree on that point, but before you go on that, could I get clarification? The first motion is clarification on the 300-foot border, and I just want to make sure that all of us agree on where that border is, as given by the map I submitted.
Listen, this is something that goes into law enforcement, and it has to be very simple. This is not something where the court can attach a map and indicate you can go here and you can't go there. It's not the court's discretion to, do this kind of a thing. This has to be an easily ascertainable standard that law enforcement can understand. They are not going to have access to maps. They are not going to be able to look at this information that you've provided. And so the amount of relief that you're going to be able to get here is somewhat limited, Mr. Moriwaki. Do you understand?
I understand that. What I presented was this is what the council presented, because they of course wanted the minimum amount of barrier possible. So they picked the furthest most corner of my property, of which I can't even access. It's behind the dumpsters and all that.
This was just a rough discussion at the time. It was not, the court does not take maps and draw boundary lines and make this kind of a determination. So I think what you're asking for is not something that you're going to get as a part of this court order or any court order. It's going to be a foot determination from the House workplace. And unfortunately, there's some perhaps lack of clarity in your mind about that, but I'm not willing to go into a place where we're going to get out maps and measure things with GPS and draw boundary lines.
Well, that's disappointing. So, according to that decision, the petitioner could theoretically be in Winslow Green, because I demonstrated that with the maps. He's within 200 feet of my place.
He's not to surveil you or have any contact with you. If he was standing on the edge of Winslow Green where you live and it was determined that his behavior was surveilling you, that's still a violation of this order.
All right, good enough. Fair enough. Okay, on the second part, Your Honor, the whole point of the cyberstalking statute is the intent to harass, intimidate, torment, embarrass, and all the rest. And the statements do that. It's pushing me to try to kowtow to a position that he wants me to agree to, of which I do not agree with. And when he took down those posts, he took them down the same day that he closed the page and made it private. These posts, some of those were almost at the same time, so being of age or older is irrelevant. It's the content of what he's saying about me, because this is attacking my character. He's trying to say that I somehow refuse to do what he wishes. All that kind of behavior is, in its definition, stalking and harassment. So that's what those posts are. And so that's my point.
If they are violations of the court's order, then your remedy is to contact law enforcement and report them as a violation. And the position of the respondent is that they're not violations. And these are some of the issues that are going to be discussed in more detail at the full hearing. But at this point, I'm not seeing that there's any information that's so egregious that the court feels a need to take action beyond the temporary order that's already been issued.
Mm-hmm.
And, Your Honor, this issue has also been addressed already with a detective. I was contacted before the prior hearing about this very issue, and nothing came of it. The detective was in agreement with me that it was in compliance with the court order. And this, again, was discussed at the last hearing. And so this is now the third time that the petitioner has brought up this issue, and it's getting quite redundant.
Okay. Well, I've explained and clarified. I'm not issuing sanctions as requested by respondent. I think that it's sometimes confusing to people who are going through this process representing themselves as to where the boundaries of the court order lie. And Mr. Moriwaki is attempting to present his case, and I have indicated at the last hearing and today that these issues are deferred for the full order hearing. So I think we've addressed all the issues here today. We will have another status conference on this matter on June 20th at 1 p.m. Again, parties may call in or appear in person. It's up to the parties. I am going to need the respondent to sign a copy of this order. Counsel, did you want did he want to come to the court to sign that order, or is he going to sign that through you and send it back to the court?
If you can have Madam Clerk email it to me, and I can then have my client sign it, and I can send it back to the court. That works for you, Your Honor.
Okay, we will do that. All right, anything further?
I just want to confirm to make sure there's no confusion. So June 20th is going to be a status conference meeting, just updating as to whether or not there are criminal charges are being filed, and based off of that, we may be setting it for a full-blown hearing shortly thereafter, correct?
Correct.
Okay, just want to make sure. Okay, thank you.
Well, please re-clarify that. I originally heard you, Your Honor, say the status hearing on June 20th would be if there is any kind of information about any kind of criminal charges pending and or proceeding, but we will continue from that point, because this could go on for a year because they don't do anything. I mean, there has to be at least some point where this court has to take action on the civil matter.
And we have addressed that. My client has indicated to me that if a decision has not been made by the 20th, currently he's inclined to probably proceed shortly thereafter. So my guess is if a charging decision hasn't been made by the 20th, I suspect we'll probably be setting for a hearing in early June, a couple weeks later. That's my guess.
You mean early July?
That's what I meant. My apologies. Yes.
I'm sorry.
So then, I just want to make that clear that is what your client is saying he would do. That if there is no criminal charges and or proceedings by June 20th, then we can proceed with this civil matter of the protection order.
No charges. If there are charges, then that's going to be a different issue.
Correct. We take one motion at a time. I understand that you want this resolved quickly, but unfortunately certain civil litigation takes longer than one would necessarily want, and there are legal reasons for that, and the court has iterated those legal reasons for granting the request for the continuance, which is only the second request for continuance. It's reasonable in nature, and so we're going to proceed that way. All right, so June 20th at 1 p.m., you may call in or you may appear by telephone, and then we'll address what will be happening next at that time.
Thank you very much, Your Honor.
Your Honor, just for my clarification again, if there are no charges at that point, there's nothing happening then, as I heard from counsel, then they will have, the client said that he would move forward with a full protection order hearing in early July.
That's what he anticipates his position to be, yes.
All right.
All right.
Thank you.
So we will send copies of this to everybody. Do we have Mr. Moriwaki's email?
Yeah.
I believe we probably do. If not, the clerk will give you a call back.
Yeah, it's in my name at Gmail.
Okay. Through his attorney. Yeah. All right. That'll conclude this matter.
Very much, Your Honor.
Thank you.
Thank you.
All right, bye-bye.
All right, and the next matter is the matter of Sandra K. versus Vincent DeSantis, cause number 24-17. Is Ms. K. present? Let's see.
Yes, she is. You ready for it?
Yes. So, do we have Mr. DeSantis here?
Yes.
Okay, so you may have a seat actually at this table right here, and then she's going to have a seat right over here.
Yeah, I bring a counsel up.
Oh, do you have an attorney?
I'm
No.
an attorney, I'm his coach.
No, you may not. You may not represent him like an attorney. So you can have a seat here, and you, if you're a witness, you can remain there. And then we're going to have Ms. Kay, who's a petitioner, come in, and then we'll talk about how the matter's going to proceed.
I have copies of documents, Rob.
Okay, just a minute. We'll talk about what's going to happen as soon as everybody's in here. All right. So we are here on the matter of Ms. Kay versus Mr. DeSantis. This is cause number 24-17, and this is a request for a civil protection order. The court's going to explain how this is going to work. So this is a civil matter. By the court rule,